You'd be shocked how many people tank their personal injury claim before they even leave the scene. They might post something on Facebook, apologize to the other driver, or try to be nice to the insurance company. But if you do any of that, your claim and the value of it could be slashed, or you might destroy the whole thing altogether and it be denied. We're personal injury attorneys with Blackburn, Romey here in Indiana. And in this video, we're going to walk you through the most common mistakes that can destroy your car accident claim before it even starts, so that you can protect your rights, avoid losing thousands, and give yourself the best shot at full compensation for your claim.
So talking to the insurance company, it's dangerous, but why? Well, let's kind of dive in and find out. Insurance companies and their adjusters, they may come across as really nice, compassionate, and empathetic right off the bat. But you got to remember, they are not working for you. They are not trying to help you. They work for a company, and the company is trying to seek profits. So at the end of the day, they're not looking out for your interest. They're looking out for their own, which is protecting their profits. They are not on your side. And you need to know that so that you can talk to them in a manner that protects yourself. One of the first things that they're going to want to do is tell you that they need to get a recorded statement. And it sounds very simple. It sounds as if this is normal. It's routine.
I can't process your claim without it.
Oh, it's the first step to open the claim. And without a doubt, that is wholly inaccurate. They don't need it. They want it. Okay. Let's talk about our recorded statement and what our recorded statement actually is.
Yeah, so the insurance company is going to call you up, and here we're specifically talking about the other party's insurance company. With your own insurance company, there is some level of have to cooperate. We still encourage you to talk to a lawyer before you cooperate too much. But when it's the other party's insurance company, they're going to call you up and they just want to do a rundown. Hey, this is Bill from ABC Insurance Company. I just needed you to tell me everything about the accident. And they want to lead you through a list of questions.
And these questions, they have training on this. They have a specific set of questions that they ask. They've got an outline. So they're very well prepared to ask these questions, but also ask it in a manner that is favorable to the insurance company.
Yeah,
as opposed to you.
And again, I'm pro-business, right? I'm pro-business. I understand insurance companies have a profit motive, all right? However, when insurance companies are calling you after your accident and looking to put together their file, they're gathering evidence just like you should be. There are a few different things that insurance company wants to ask you during a recorded statement, right? So they want to find out how the accident happened. They want to find out about your injuries. The tricky part is when you say things on the phone that can be taken out of context, or that if you are not incredibly precise,
Or if you think it's a casual conversation.
a casual conversation, is your statement is now part of the record. Okay, so if you say something as simple as, I didn't see them coming, well, gosh,
That's it.
and that's it, well, gosh, weren't you looking? Weren't you looking? Or sometimes I had a case recently where there was a statement from a witness where she said it was interpreted to say that there was a vehicle that was involved that didn't have its headlights on. Because she said, I didn't see any headlights. I spoke to her after the fact. She said, I never said that. I never said that the vehicle didn't have headlights. I just said I didn't see whether it had headlights or not. And so the way she gave the recorded statement, though, it certainly seemed to be that she was saying that vehicle, I saw it and it didn't have headlights on, when it was actually opposite of that. I never saw it, so I can't say whether it had headlights on or not.
The psychology behind a recorded statement, again, the adjusters are trained. They've got the outline in front of them, and they know how to ask questions in a light that helps the company, not them, and not you, rather. And so they're probably going to ask you what's called a leading question, where it has the answer built in, and it's open to interpretation later on down the road. But the psychology there is, again, the insurance company, the adjusters, they're not working for you. They may sound as if they are, but their job is to document the file and try to get the statement.
And there's also going to be some questions in there that they ask, which can be very beneficial for them if you mess up. They might ask for measurements of things. Hey, how long was it in between the time you entered the intersection and the moment of impact? How long was it, or how far away were you when you first noticed the other vehicle?
How much time went by?
Yeah, so
Or distance.
they're asking for measurements of time, speed, and distance, and I haven't had a single client measure those things during an accident. But now all of a sudden after the accident, you are asked to give precise measurements for these things that you have no idea about. And so if you give accurate measurements, let's say you actually knew all the measurements, frankly, probably doesn't hurt you that much. It's when you guess and your measurements don't make sense, or they allow a liability argument to be made against you now, and you've stepped in it unknowingly. You thought you were having a casual conversation.
Yeah, so here's a little tip. One, don't give a recorded statement. And certainly if you are talking to an adjuster and you learn this after the fact, you want to stay away from time and distances. We hear it time and time again where the question might be, well, how much time elapsed between when you first saw my client and the collision happened? So most of the time, that's probably going to be split second scenario. Not always, but you hear strange things like, oh, 3 minutes or 5 minutes. And realistically, if you sat there and you started your stopwatch, it would seem like an eternity. So first and foremost, biggest tip here is do not talk to the insurance companies and give them a recorded statement. But the reason why is the law of comparative fault in Indiana. Chad, what's comparative fault?
Comparative fault. So if you think you have a pretty clear case, well, it was their fault. Well, in Indiana, it's not always that simple because we have what's called comparative fault, where if the other party did most of the negligence, if they were mostly at fault, they ran the stop sign, but gosh, you were going 10 miles per hour over. Well, you might be partially at fault for that accident. And it's those little comments you make during your recorded statement that can lead an insurance company to say, you know what? Even if we can't get a jury to believe that you were 10% at fault, we're going to make our offers as if you were 10% at fault.
Great example, Chad. So speed, that's a big factor. And they'll use that analysis when they evaluate the property damage too. So a lot of times you may not have the police report and you may not remember the speed limit of the road you were traveling on. If you had the police report, you could see, oh, it was 55. They're going to ask you the question, well, what road were you on? What road were you traveling? Where were you coming from? How fast were you going? And if you don't remember and you think, oh, I think I was going 55 miles an hour because that's just in your brain, but the police report says 45, then at that point, you kind of hurt your case without really even knowing it.
Yeah. It doesn't mean you were going 55. It just means you said you were going 55. And when in reality, you don't remember. And so I talk to my clients a lot as we get later in the process. You don't testify in a deposition to things you don't know. You don't guess. You don't try to fill the gap. And the same thing goes for recorded statements. Because what insurance companies aren't telling you is you're not required to talk to them. Again, there might be some level of requirement when you're dealing with your own insurance company. You have to cooperate. But even that, we say, hey, make those recorded statements with us on the phone. Another thing that you might be talking to the insurance company the day of or the day after the accident. You might not be in pain yet. Your pain might not have set in yet. I've had clients who didn't realize, gosh, my neck is really, really sore. And here we are 3 days after the accident. They didn't have any other incidents, but sometimes it takes a while for injuries to develop.
Other side of the coin, you may have been prescribed some prescription pain medication or some other medication that makes you feel a little loopy. And so now you're giving a recorded statement. Well, you may not be as clear as what you normally were if you haven't been on the medication. And that may not come out because unless you specifically say, hey, Adjuster Bob, by the way, I'm on Vicodin right now. If it's not in the record, then that's something you could testify to later, but then it becomes somewhat problematic it becomes problematic.
Yeah. So things you say in a recorded statement can be twisted. And I hesitate to say that all these actions by an insurance company are nefarious, like they're out to get you. What I'm saying is their business model is to make money. And if they can use your recorded statement against you to interpret your statements in a certain way, they're going to do that. Because it is in their best interest to do that.
By the way, if you don't know what the word nefarious means. I don't either. I'm going to have to Google that one.
Yeah. Yes. It's a big one. It's a big one. It was on my calendar today.
Nefarious.
Just like it sounds. The other thing an insurance company is not going to tell you is it costs nothing to talk to a lawyer up front. Okay? In Indiana, actually, the insurance company is allowed to contact you immediately after an accident. We cannot reach out to folks who haven't asked us to do so for 30 days after an accident.
And even then, we're sending a letter in the mail.
Yeah. So an insurance company has unfettered access to you, and they have decades of experience. We can't help you in that process unless you ask us to do so up front.
The deck's really stacked against you. So you have an adjuster who might have 20 years adjusting claims, and they've seen it all. And now they're talking to you. This is your first accident. And they're just running the mill. Hey, first thing I'm going to do is I'm going to get your court statement. We're going to get this thing going. That way we can get that way we can get you taken care of. And so the deck's stacked against you from that perspective.
So how does a lawyer kind of change the game? How does a lawyer change the calculus here for you? I think I've always looked at it as a lawyer is kind of bridging the gap for you. There's a leveling of the playing field. I guarantee you, insurance companies that are worth multi-billion dollars are not shaking in their boots when they see a lawyer show up. But what they do is they know the playing field is now leveled. They know that you know what your case is worth or the proper steps to jump through because you have proper representation. Again, it's not, you see commercials on TV about lawyers or insurance companies are now like so afraid of the lawyer. They're not. It's part of their business model, and they deal with us differently than they deal with folks who aren't represented. And that comes out by their own studies. They absolutely deal with folks differently when there's a lawyer involved. So
she gets escalated to a different case manager who has litigation experience. Not always, but usually that's the case.
Yeah. Another role that the lawyer is going to serve, especially early on, is really just a buffer, right? So meaning once we're involved, an insurance company isn't allowed to call you anymore. Those calls have to go through us. And sometimes it makes sense for, hey, on the property damage, why don't you call the client directly, but don't talk to them about A, B, and C. Okay. But you can certainly help them get their car fixed or totaled out.
The buffer can be huge because you're in a position where you're hurt, your car may be totaled. It's your only way to get to work. You have no way to get to work at this point. The insurance company's dragging their feet, getting you a rental car. You're laid up in bed, and the last thing you want to worry about is some adjuster who's trying to call you, get your statement, or sending you documents that you have no idea what the heck that they are, but they want your signature on, and you've got to sign this right away. The buffer can be a tremendous thing.
It's very important, very important. So how is attorney involvement changing the outcome? Well, first of all, there's that leveling of the playing field that we talked about. Now you have somebody on your side that knows how these things work, and that is huge. Obviously, we're going to make sure that the medical treatment is presented through documentation in a way that makes a lot of sense for insurance companies to be able to handle. We're going to gather early the key evidence before it's gone. We handle negotiations with the insurance company, communications, both before and after negotiations. And then through insurance companies' own studies, a lawyer being involved increases the settlement value. The insurance company owes you something for your claim. If you have a legitimate claim, they owe you something for it, and they're looking to buy it from you. It's called a settlement. They want to buy that claim from you. And so that claim has a value, and it's only makes sense that you get the proper value.
Remember, they have a duty to protect their client, their insured. And really what they're trying to do is to get a quick settlement, get you to sign a release, which then releases their insured, and case closed. So if you've talked to an insurance company, well, now what? Does that mean you don't have a case? Does it mean that you can't talk to a lawyer? No, that's actually far from true. If you talk to an insurance company, it doesn't mean that you don't have a case, and it doesn't mean that you still can't talk to a lawyer. You're still going to want to document. And the things that can happen for you once you consult with an attorney at that point is attorneys can come in, they can, again, act as a buffer, but we're going to have access to getting things that have already happened. So if you've made that recorded statement, we're going to get it. If you hire a lawyer at the beginning and they want a recorded statement, about 9 times out of 10, we're going to say no. Probably more accurately, 99 times out of 100, we're going to say no. But we might allow a casual conversation. That way there's nothing on the record. Now, if we're talking, quick tangent here, if we're talking our client's own insurance company, we have a duty, they have a duty to cooperate. So they're going to make a statement at that point. And so we'll be there to listen in and object when needed. But the line of questioning still doesn't change. They still have a duty to their insured.
Yeah. When dealing with an insurance company, there are two types of adjusters, how I look at it. You have the adjusters that are very, very nice to you. Okay. And they might be a legitimately nice person. And then you have the adjusters who are, it's really painful to get on the phone and talk to them. They are not nice. They are condescending. They are rude. They are short. They're not very helpful. Both of those adjusters have the same duty. And that duty is to their company. It is not to you. Both of those adjusters have the same goal, is to resolve your claim for as little as possible. Okay. On the first one, the very nice person, you always think, gosh, Bob's out to help me. Gosh, he did everything he could. He went back to talk to the manager, and that's the best they can do. The other strategy.
It was also the first offer.
Yeah, it's the first offer. It's the best we could do. I'm here for you. I'm here for you. The other type of adjuster, very, very rude, very mean, is someone you just don't want to deal with. And God, I'm just to be done with you, I will accept your offer. Right. And so both strategies are effective at getting to the goal the insurance company has. So when you are dealing with those folks, you need to remember some things. So look, I'm still getting medical treatment. I'm not ready to talk about my settlement. Please stop asking me. Right. Please direct all the questions to my attorney. That's probably the one you should go with from the beginning, because again, that allows us to serve, or allows your attorney to serve as a buffer for you between you and the insurance company. All right. You have the right to pause any discussions with the insurance company in order to protect yourself. There is no rush to get through your claim unless you're up against your 2-year deadline, in which case you need to look at that pretty hard and heavy. So unless you're up against your 2-year deadline.
So the real question kind of becomes, well, when should you talk to a lawyer? And Jen will always tell you that you can talk to the lawyer as soon as you possibly can. Let me give you 2 real world examples of a client who came to me, decided not to hire me, and then later on, about a year and a half went by, maybe a little bit longer, and then came back and then hired me at that point, compared to the client who just hired me from the beginning. So client A came to me, very nice, decided to handle the case on their own, and unfortunately, they weren't able to resolve their case. Came to me about a year and a half down the road. And it really put them in a position where their case lasted longer than it needed to, because now they're coming to me. It's already been a year and a half or 2 years, and I don't have any of the documentation, so I had to get up to speed on it. The same scenario with same or similar type facts. That client comes to me and hires me right off the bat, and we were able to get everything we needed right from the get-go. We start working with our investigation. We're going to the scene. We're getting pictures. We're talking to the witnesses. We're accumulating the medical records. We're talking to our client about their treatment and some of the troubles that they're having. But we worked that case up, and we were able to get a settlement at about the same time that the other client just came back to me. So not every time is a lawyer going to get your case done faster. It all depends kind of on the insurance company as well. But certainly, the quicker you talk to a lawyer and potentially hire a lawyer, the quicker we can get to work, as opposed to getting to work 2 years down the road.
Yeah. So here's what you need to remember. The insurance company's job is to pay as little as possible. That is their business model. Take in premiums, pay out less than that in claims. Talking to an insurance company before you talk to a lawyer can either ruin your claim completely or significantly decrease its value. Indiana law does not require you to give a statement to the other party's insurance company. And the sooner you get a lawyer involved, typically the better outcome you're going to get from the processing of your claim. If you've been in an accident and you're not sure what to do next, don't risk your future or your claim's future by making one wrong move. Get advice first. It can be a 20-minute phone call. It could mean the difference between a fair recovery and a lifetime regretting the decision. Now, if you found this helpful, you absolutely need to watch our next video, how to counter a low personal injury settlement offer. Insurance companies often start with a lowball number, a very low offer, hoping you're going to take it without question because you think you have to. In the next video, we're going to show you the steps that you can take to fight back and get what you deserve.
Don't leave your claim up to chance. Click over to how to counter a low personal injury settlement offer and learn how to protect yourself.
See you over there.
Bye.